Hi, I'm Saren Coach with Alt Legal, and I'm here today with Ruky Tijani, founder of Firm for the Culture. Ruky is going to be speaking at our upcoming virtual trademark conference, Alt Legal Connect, on September 13th to 15th, and we're very excited to have her join us. So, Ruky, tell me about your session and what you'll be talking about.
First of all, Saren, thank you so much for having me, and to the alt legal community. I'm super excited to geek out with some of my favorite colleagues in the trademark practice. So my session is going to, it's called Spring into Office Action, dealing with and overcoming OA or office action refusals, where me and my esteemed colleagues, Eric Pelton and Kaylu Sullivan, will discuss some of the thorniest office action refusals that trademark applicants and practitioners face. And then we'll also discuss some successful arguments that have been used historically to overcome such difficult refusals.
Great. And what is most exciting about your session topic?
What I love most about the topic is that it's really, really practical. When Eric and Kaylu and I had a discussion prior to the presentation, we really talked about getting into the nitty-gritty of some of the successful arguments that have historically been used to overcome some of the thorniest refusals. So to give you some context, some of the refusals that we'll be talking about are the likelihood of confusion refusal, also known as a 2D refusal, the descriptiveness or merely descriptiveness refusal, also known as a 2E refusal, and the seemingly increasing failure to function refusal. So because it's so practical, it's given me as a trademark practitioner and a trademark nerd the ability to really dig into some of the knottiest and seemingly impenetrable office action refusals that even the most seasoned practitioners really can't seem to overcome. So I've been tasked with discussing the failure to function refusals, and particularly against the backdrop of a growing online entrepreneurship and social media community, failure to function refusals have really grown in response to applicants attempting to trademark or exclusively own phrases or slogans that have become wildly popular, and thus, as the USPTO notes, very commonplace. So some popular terms that I'll be discussing includes Hot Girl Summer by Meg Thee Stallion, Taco Tuesday by LeBron James, and Black Lives Matter.
Sounds good. This definitely is going to be so useful. I can imagine for attorneys just starting out, but also seasoned attorneys who've been doing this forever and need to get a refresher and understand what's happening with failure to function as that's becoming a wider net that these examiners are casting.
Exactly. And that's really because, there's just been a deluge of applications filed with the USPTO over the last year. And a lot of people, I think because, applying for an application, aside from actually searching and determining if, it'll register, simply applying for an application is relatively simple. It's relatively straightforward. So a lot of people, response to viral words or viral phrases may go ahead to the USPTO website and apply to trademark a particular phrase. Like for instance, earlier last year, like tens, if not dozens of applications came in that had the word corona or COVID in it in response to the COVID-19 pandemic. So that's what we're going to be discussing, and hopefully we'll be able to provide significantly practical insight into overcoming such thorny refusals.
Yeah, no doubt that's going to be super helpful and very interesting as well. What is the most important skill or piece of knowledge that people will get from your session?
I think it really is like getting into the nitty gritty of the argument. So we'll be able to, first of all, demystify what a failure to function refusal is against the backdrop of, the Lanham Act, the Trademark Act. And as a result, we'll be able to quell a lot of anxieties tied to this and other thorny office action refusals. And we'll learn by unpacking, paragraph by paragraph, successful office action responses. We'll learn how, other practitioners or other applicants have overcome such seemingly difficult refusals. So that's what I'm really, really excited about.
Sounds good. So what is the most important information you learned about when researching your session topic?
Yeah, so for me, I think before I answer the question, it's important to put into context that I am a millennial. I'm from Brooklyn, New York. I love pop culture. I love, just kind of exploring the intersectionality of intellectual property, social justice, and pop culture sometimes. So one of the things that I recently learned was that Meg Thee Stallion, who, is a wildly popular musical entertainer, recently overcame not one, but three failure to function office action refusals for the term hot girl summer, which went viral, was a term that went viral and received so much, use in the marketplace in the summer of 2019. So after a protracted 2-year-long battle, which included appeals to the trademark trial and appeal board, her mark was at least as of the time of this recording, her mark was sent to the official Gazette, which is the next to last step for registration. So considering, again, how wildly popular the term hot girl summer became, the case of Meg's application is really a great case study to unpack. So we're going to be looking at the arguments. We're going to be looking at the evidence that was submitted to overcome the failure to function refusal. And I think because it was such a long battle that included appeals to TTAB, it's going to be a lot of great arguments and a lot of great evidence to really unpack and assess to determine how she overcame a refusal that a lot of people said could not be overcome.
That's going to be absolutely fascinating. I can't wait to hear about that one too.
Yeah.
So I know you attended a Connect last year. Can you tell me what was your favorite part of Alt Legal Connect last year?
Oh my gosh. So my favorite part was really the community. So one of the things that I love about Alt Legal, like not only the webinars, but the sessions, is that the chat with virtually every session is always lively. So people are connecting with each other, people are chatting with each other, people are asking multiple questions. So the community is really something that I'm looking forward to. Some of my closest colleagues that I've been able to engage with over the last year are people who I met at Alt Legal. So I love that the conference platform that we used last year, and hopefully we'll use this year, really allowed us as practitioners to network with each other between sessions. So that's one thing I'm looking forward to this year.
That's so great. I'm so glad to hear that. We did hear so many positive things about our networking platform, which will be the same this year. We're going to do the icebreaker, social networking, speed networking event again. And also the chats. People were just loving that. And also, I don't know if you got part of the WhatsApp group afterwards. Did you hear about that?
I made the WhatsApp group.
Look at that.
I was the one that made.
Amazing.
I was the one that made the WhatsApp group. So yes, I heard.
I want in on that group now.
Yeah.
That's amazing. So cool. So, okay, what are you most looking forward to about Connect this year then?
Really, again, meeting members of the community, meeting people who are really excited about the work they do. And also, I think just in light of recent changes in trademark law, discussing some of those recent changes. The last year brought about some major changes, especially with the rollout of the Trademark Modernization Act of 2020. So I'm really looking forward to learning the tips and tools that trademark practitioners, are going to adopt to help their clients and to help their communities own their brands. So yeah, that's what I'm looking forward to.
Sounds good. And in the same vein, besides your own session, what session at Alt Legal Connect are you most looking forward to?
Oh my God. So there's so many good sessions. Alt Legal always just does a great job in providing really, really practical and timely sessions. But I would have to say, the one that I'm really looking forward to is called Be Fab with TTAB. I'm pretty sure that was a play on words from Brie, but Be Fab with TTAB, tips for successfully pursuing, defending, and settling TTAB or trademark trial and appeal board disputes. And I'm excited to just simply learn more about TTAB proceedings. As a prior litigation attorney, it's always really good to just kind of return back to that world with really rich knowledge of trademarks in particular and intellectual property in general. So I'm excited, and I'm really excited to see what the panelists discuss against the backdrop of the Trademark Modernization Act, which is, intended to really change the landscape of TTAB in the sense of making us determine if we're going to go ahead and cancel a mark that may not have been used for a long time. I know Trademark Modernization Act gives us a lot of avenues to, take a mark off of the principal register without going to TTAP. So I want to get a sense of what that interplay is going to look like in light of the Trademark Modernization Act.
Yeah, that's a really interesting angle. And that's going to be a great session in general. So I'm glad you're looking forward to it. Well, Ruky, those are all the questions I have for today. We are so excited to have you speak at Connect. And I just encourage everybody out there to connect with Ruky on the networking platforms. She's amazing. Thank you so much. And we'll see you soon at Connect.
Okay, bye.
All right, bye.